welcome Sally Yates, Alberto Gonzalez. Pleasure to have you. It feels to me like we have to start with what seems like a blockbuster Supreme Court ruling, the birthright citizenship case. And I just want to lay out as I understand why it's so significant and then hear from both of you your reactions. What it seems the court decided to do was to take this case and rule specifically on the procedural aspect of it, which is actually in some ways as important as the substantive one. The substantive issue was, can somebody born in this country be given a citizenship automatically? Is that a birthright because you were born in this country? The procedural issue is, can a district court judge issue an injunction, a kind of stay order, across the nation? And what the court said was no. You can only provide specific remedies for the person who sued. What strikes me, Sally, is nationwide injunctions have been, for, you tell me, but for decades and decades, I think, a very important part of the way courts limited executive power. Am I right? What do you think is going on here?
Yes, nationwide injunctions are nothing new. Now, to be honest, presidents have always hated them, whether you're a Democratic president or a Republican, because they are used as an effort to rein in actions of the executive. But nationwide injunctions also make sense. If you think about this, if a court has determined that the action of the executive is unconstitutional or unlawful, which is what the courts, all three courts to have considered this matter did, it really doesn't make a whole lot of sense that it's only unconstitutional as to the particular litigants who brought this. So that's been sort of the basis for this. It's not that the district court opinion lives on forever. There is an appeal process after that to the circuit courts and ultimately to the Supreme Court to decide the substantive issue. But that nationwide injunctions are nothing new. Now, you can talk a little bit about Justice Barrett and her determination that they didn't exist back in the 1700s. And that was the reason why it was not going to be permitted today. But it's not a new thing.
Alberto, what is your reaction to that ruling?
Sally's right. All presidents, recent presidents, certainly have really chafed over the issue of nationwide injunctions. And I think for the layman, it does seem kind of weird that some district judge in Pecos, Texas, issues a ruling and binds the United States of America. So in that sense, to me, it seems a little weird, quite frankly. I think this decision does not affect the substantive issue of birthright citizenship, which I suspect we'll talk about. I think this was a way for the court to look at the issue presented, rule only on the issue. As a judge, I learned that you're only on the issue before you get in, you get out. And I think that's what the court has done here. I think the bottom line is it really is going to enhance executive power. We've had recent presidents, both Republican and Democrats, that have expanded or certainly expanded the use of executive power.
I want to ask you about the politics of this. When Biden was president, there were several nationwide injunctions against him on core issues of his agenda. The court never seemed to mind. In fact, in one case, as I recall, I think the student loan one, they reaffirmed the nationwide injunction. So they suddenly discover when a Republican president is in office that the presidency has much greater powers than they thought it did 3 years ago.
Let me give you a possible scenario, and I have no basis whatsoever to reach. It is possible that the court took this case to decide the substantive issue. And as they negotiate what the opinion should read, they discover they don't have 5 votes either way.
Interesting.
And so as a result of that, they decide to punt the substantive issue and deal only with the nationwide injunction.
That means you think the court is deadlocked as to whether the 14th Amendment grants birthright citizenship?
Well,
it seems pretty obvious.
Well, it seems obvious to me.
Yeah.
I don't know if it's so obvious to Sally, but it seems pretty obvious to me. And I think that there are at least 5 votes to affirm that, and perhaps the only way to get this opinion out was to carve away the substantive issue and deal only with the nationwide.
Let's talk
If
about
we don't have 5 votes on this, we're all in really big trouble.
Judge, I want to give you the chance to talk about what is behind this in a sense, because there are core members of the kind of Project 2025, and it's been true with some Federalist Society people, believe in something called the unitary executive, believe the executive should be much stronger, and I think specifically think that post-Watergate, the executive branch has been constrained, and that this is an effort to kind of unshackle the executive branch. Is that, do you think these are legitimate moves in that direction?
I think that there are a group of individuals who I respect who believe that the executive power of Article 2 is invested in the President of the United States. And it is the President of the United States who decides what the law is for the executive branch, not for the government, certainly not overruling the Supreme Court. But the President of the United States, traditionally, a traditional White House, you have 20,000 lawyers, roughly 20,000 lawyers that work within the executive branch. And, they advise the president, and that's the way it normally works. This administration has brought that legal decision-making into the White House. And honestly, I think you can do that under this theory. And so he surrounded himself with people that are loyalists, and so all the people that might oppose him and tell him no are gone. And again, but if you believe in the unitary theory, the President of the United States can decide what the law is for the executive branch, and he can tell the Solicitor General what the brief should say when it goes up to the Supreme Court.
So you sound like you're uncomfortable with a lot of the things going on, but you don't seem like you're agitated. Is it because you view this as a 2-alarm fire, or is it a 5-alarm fire?
Well, it's certainly very different than the president that I worked with and the Department of Justice that I led, and I know that Sally also worked in. And it makes me uncomfortable. In the hands of a person with integrity, I have a lot less concern. The main concern I have is that I don't believe that Donald Trump has the integrity necessarily to effectively govern fairly this country.
But in a sense, that is the genius of the Constitution, right? Madison says if men were angels, no government would be necessary.
Absolutely.
Right? So we're planning for self-interested people and power-hungry people, and that's why the checks are so important.
But talking about checks, if I can just, Sally, say this, I'm most disappointed, well, maybe not most disappointed, equally disappointed in the Congress. They have the power over appointments, they have the power over funding, and they're doing nothing. Right. And so I don't understand it. When we worked in the White House, we respected, because we were forced to respect the authority of Congress. They would always tell us, this is our prerogative, you can't do this.
It is striking what Alberto says, that Congress, the administration seems to be deliberately flouting Congress. So, for example, when they fired the inspectors general, the law, which Congress had written, merely said that the president had 6 months' notice and a valid reason. The Trump administration almost defiantly fired them all instantly with no reason. And Congress didn't say anything. Didn't say, can you just at least follow the damn procedures, and 6 months later all these people will be gone. But it's almost as though, as I say, as a point, they're trying to make a point that post-Watergate, this executive branch has been shackled, and we are unshackling it.
Yeah, I wouldn't say it's almost defiantly. I think it was defiantly. And that seems to be the mode that this president has been operating in, particularly here in his second term, which is almost I dare you to do anything to try to check my power. And unfortunately, it seems like most everybody's cowering in that, whether it's Congress, as you were pointing out, or businesses or universities sometimes or others. And so once you get that power of intimidation, you don't even have to tell people what to do anymore because they are obeying in advance. They know what you want, what he wants them to do, and they do it. So I think this is all part of a diabolically brilliant scheme to be able to concentrate power in the presidency. And I totally understand your point, Judge, about Article 2 vesting in the president, the power and the responsibility to take care that the laws are faithfully executed. And so constitutionally, may the president tell the department what to do? Yes. But I would say the same thing that I used to say to brand new prosecutors who would come to our office, and that is, just because you can, that doesn't mean you should. And for over 50 years since Watergate, Republican and Democratic presidents alike and attorneys general alike have recognized that the rule of law requires that the White House, that the president not be reaching in to try to determine individual cases and prosecutions.